because there are people that are, okay. So we are ready now. Mr. Ngombane is ready. Our chair is ready. Mr. Nkosi is also ready. I want to say good afternoon to everybody that has just joined us from Facebook and everybody that has just joined us from Zoom and joining this awesome lecture that we're going to have today. This lecture is going to talk to you about common law in the modern day in South Africa. This is part one of two-part series that we're going to have. So make sure that you've got your pen and paper ready, because the advocate is going to be dishing out information that will be beneficial for you going forward. So I would like to introduce our chair to open the meeting for us, and then we'll take it from there. Over to you, Chair.
Thank you, leadership. Thank you very much for this, the introduction and this opportunity to talk. I would like to first welcome EU Leadership Site, the advocate, and thank him very much for agreeing to come to this platform to talk to us about this very incredible topic of common law in the modern day South Africa, juxtaposing the constitution that we have, which is commonly said is the best constitution in the land or in the world. So just quickly to introduce who we are. Can somebody mute there, please? I'm being disturbed by that. Thank you. So first of all, let me welcome everybody, including those that are live on Zoom, those on Facebook also live. First of all, to introduce the South African Leadership Club, we are a national NPO for men and boy child, whose purpose is nothing else but to develop each other, all of us, into being responsible, outstanding leaders of our communities and our families, because that we haven't seen in a very long time. We believe that man has handed over the responsibility that God gave him over to the state. And it is for that reason that today we're sitting with half the population of the nation unemployed, half men of this country busting in jails, and families living in abject poverty. So for that reason, we believe as subject that a man needs to stand up and wake up from where he's sleeping and take over his responsibility that was naturally given to him by God. So we looked at the circumstances of how our country is suffering, and we thought there were many hypotheses of how we can solve the challenges of our country. And ultimately, we realized that the challenges that have engulfed our country are not really political or economic or anything. It's lack of leaders from each one of us, not lack of a leader on top. So the basic thing is we're doing leadership development from the bottom up, because it's not happening from top up, from top down. So the hypothesis, as I said, was what could be the antidote to this challenge. Ultimately, we settled to the antidote being the 5 founding pillars of this club, to which one of them is liberation of the man's mind and the boy child's mind in partnership with various stakeholders. We have agreed on that as one of the top pillars of the club, which is actually the one that has brought us here today. We have this topic because we want to liberate the mind of the man and the family, because this is also a family show, so that we are able to see, to invest in the mind. But if you invest in the mind that still leaks through its own crevices, everything that you invest in it is really going to leak out. So we're trying to get the mind right first. And once the mind is right, we'll be able to address all other issues. That's what we are doing here at SALJ. But there are people who will be saying, we hear that and we understand we want to liberate our minds, but we have problems as men, psychosocial, economic problems. Yes, all these pillars, 4 or 5 of them, they address the psychosocial and economic challenges. I'm pointing out this first one of liberating the man's mind, particularly because it is the one that has brought this leadership lecture that we often have, leadership seated every twice a month on this platform with different speakers and different topics of national importance. So it is for that reason that we are saying, even if you are sitting there as a man, it doesn't matter where you are in the country. This is a home for all men, and we need all men to come here. Maybe we've got social, economic, confused psychological issues. We've got programs that talks to that. within the club. We've got legal programs that teaches men about their rights, access to their babies and their children and their families, and all that. We have a program called Luala Banna, where men are being advised. You call and you talk to leadership to address all those challenges that put men at the corner to end up feeling that they are worthless. So there's various programs that this club runs. So there are people who could be logging in and thinking, if it's a club of men, we women, where are we? Are you shutting us out? Can we register and join the club as well? The simple response is no. You cannot register as a member of SALJEC because this club is particularly focused on getting that man who's shying away from his responsibility. We are chasing on all men, irrespective of your race, your social class, or anything. We want you to stand up and be responsible because everything that happens in our communities mostly has got a man being in the lead of it. That is why we target men to come to the club. However, the generation that we are building as SALJEC is such that the voice of women will always be heard as well. That is why we allow women to be in the club as friends of the club, not as members of the club. So we have a desk in SALJEC, in the club, called the desk of Friends of SALJEC. This is where women join within the WhatsApp groups of the club, and they speak amongst themselves, and they raise a voice on issues that they think are of utmost importance, or they contribute on the programs that they know that will be needed in the society. So yes, sisters, mothers, aunties, daughters, you are welcome in the club as friends of the club. Your voice is absolutely important in every family that we need you to be heard. So leadership, we chose this topic, as you and I has briefly spoken, of a man, a customary law. I mean, not customary law, the common law, because we understand that as a natural person, we are born with this law and the right given to us by God. Because when you look at common, I mean, when you look at the word natural already says it comes from the Egyptian word of Niger, which means of God. So it comes from natural law, which is the law of God, that you should not do bad to the other person, and the other person should not do bad unto you. So those are natural laws that we are born to live with. And common law is derived from those natural laws. It is the laws that are able to tell us this is good and this is wrong. Simple as that. That's a natural law that we need to live with each other in peace, not in violence and dominating each other, but dominate in your area of domination, of your skill and what you know and what you are able to share with the world. However, today, we see the governments all over the world, not only in South Africa, cooking up the convoluted and confusing laws that are meant to dominate the people instead of allowing justice to happen. I looked at our constitution at some point. I was struggling to find the word justice in that document because I thought every page of the constitution will have justice, 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 justice. That is why I ended up wondering, is this constitution really as great as it is, and where in the bigger scheme of things does it put our natural law that we were given to us by God, that me as Bo will never do bad to Sita, and Sita should not do bad to someone else. And this is wrong and this is right. There's no gray in between. The confusion that has come now is we see values are being vacillated by the constitutions and the laws of each country, where now we no longer know if bad is bad, because there's always definitions of what is bad, and there's always convoluted and confusing terminologies that are used to make sure that murder is getting away with without punishment. So we really need to understand we are dealing with difficult times now. We are in a COVID-19 situation where every one of us, our common law or natural law is taken away from us. Number one, we cannot gather unless they tell us together. We cannot speak unless they tell you that this is right. We cannot breathe fresh air that God has gave the body to breathe it in order for the internal organs to operate and function normally, because they tell you not to wear that mask. Our freedom has always been taken away through a deception of it is done on the good of all. So we always gave away our freedom because we have been told, no, it's for the benefit of all. So I see that we are almost leaving all our freedom to the hands of the few now. Is our natural law given to us as a people violated or taken away completely by the current constitution that we are living in? These are topics that, as a leadership of SALJIC, we sat and thought these are things that we really need to address. We need to waken up the people and be aware if our powers are being taken away from us, because they are not being taken away with power, with force, but they're taken away with deception. Always being told, no, it's for national good, it's for natural good, it's for national good. So eventually, when you look at it and you are able to anticipate, you can see that 4 or 5 years down the line, when you read documents like Agenda 21, Sustainable Development, and all those things, you can see that we are losing all our power, and ultimately we will not have a word to say, because the majority are holding on to the power which they are taking away from us through deceptive manners. So that is basically that. And with that, I need us to really get into it and wake the people up as to where is our constitution juxtaposing our natural law. I thank you very much. I'll hand over to the chairperson as he's preparing to read the bio and get on with it. Thank you.
Thank you very much to you, Chair. So I would like our MD, Mr. Nkosi, to kindly read us the advocate's bio. Mr. Nkosi, can you kindly read a bio, Mr. Nkosi, so that everybody on this call can understand the person and the caliber of the person that is going to lead this discussion today. So over to you, sir.
Thank you, Chair. Advocate Sithe Ngombane is married and blessed with 1 child. Mr. Ngombane is a born-again Christian and loves the Lord. Advocate Ngombane is an alumnus of both Walter Sisulu University and the University of the Free State. He joined the Faculty of Law, University of the Western Cape in 2018 and has since lectured law, criminal procedure, introduction to legal studies, and advanced civil procedure. Advocate Ngombane is a member of the Cape Bar subsequent to his passing his pupillage at the same bar. He obtained his LLM degree at the University of the Free State. He obtained his LLB degree at the Walter Sisulu University. Advocate Ngombane is an admitted advocate of the High Court of South Africa. His practice includes various branches of law, including criminal law, commercial litigation, environmental law, administrative law, companies and contracts. He has previously worked at Legal Aid South Africa in Bloemfontein Criminal Justice Department. He also worked as an in-house counsel at the Department of Environmental Affairs for a short stint. Advocate Ngombane research interests include international criminal justice, Africa's cooperation with the international community in criminal matters, criminal procedure, and law of evidence. He is a PhD candidate at University of Western Cape. His research deals with prosecution of corporations for international crimes. Thank you, Chair.
Thank you very much, Mr. Nkosi, for that bio. And I'm sure Mr. Ngombane is ready for us because we have had a born-again Christian, a father, and you practice this and you know what you're going to talk about. So I want us to welcome you and say thank you very much for the opportunity that you have given us to share this knowledge with not only our members, but South Africa at large, because after this, we're definitely going to share this. We're going to have people going onto Facebook and asking questions. So it's your platform, sir. Good afternoon.
Good afternoon, sir. I hope we are all well.
No, we are well under the conditions that we find ourselves. You know, at this moment, we can't move, we can't do stuff, we just held hostage, but we don't want to admit that we are held hostage. But yeah, we'll leave that to for another day. But what I'll say to you is let's get the ball rolling. Let's start the conversation, and I'm handing everything to you. For the next hour, the show is all yours. So welcome, sir, and the stage is all yours now. Thank you.
Thank you so much, Brother Tebogo. Executive Chairman, Mr. Bo Tabakwe, and the board,
Yes.
Members, supporters, and all those who espouse the values of the South African Leadership Gentlemen's Club. Good afternoon. First, I would like to thank Mr. Mbulelo Bikwani and the esteemed leadership of SALT under the chairmanship of Mr. Bo Tlabakwe for inviting me to deliver this lecture on this topic, common law in modern day South Africa. I feel especially honored that I give this lecture at this moment. I think at this moment it is the opportune time for this type of a lecture. But it is prudent that I begin with the term common law so that we can all have an understanding of what it means and how it developed over time. Common law is used in three senses, or in three levels. The first level we use common law is in the sense that the legal system applicable to all inhabitants of the republic, whatever their color or creed, is South African law. That is, the law that is applied is South African law, irrespective of where you come from, of your color background, and so on. And by saying that, we in effect we mean that that South African law is our common law. And in the second tier, or the second sense in which the term common law is used, is sometimes used to differentiate a type of law found in the prevailing legal system. For instance, statute law, as we know in South Africa, is proclaimed or promulgated by Parliament, is sometimes contrasted with common law to say there's a law, there's a statute law, there's a statute, there's a piece of legislation, and there's common law principles. In the sense that that portion of the law has evolved from the Romantics law expounded and expanded in the works of the old Roman Dutch writers and judicial precedents, which is critical. Then the last tie, or the sense in which a common law term is used as a classification of a legal system, indicate that the law of those regions of the world which have been influenced by the English common law. As we know that the United Kingdom mainly is based on common law, the United States of America, Canada, Nigeria, and ourselves here in South Africa, we are also a common law jurisdiction. So those are the three senses in which you can invoke or use the word common law. Now, by saying common law as the word indicate, it indicates the law that commonly applies to everybody, irrespective of their background, as I had alluded before. Now, we know, or perhaps one of the features of common law is that it is largely based on precedent. By that we mean that the cases, for instance, we've got in our courts today, a court will look at the principle of a particular case that was alluded to in 1909, 1986, 1976, etc. That is precedent, and that is the substratum or the backbone of common law. It is based on those judicial decisions that were developed by judges over time. Now, these decisions, as we all know, if you see at the background, are volumes. It can be 1 until 5, and so on, of decisions, case decisions that have been accumulated, recorded over time, and now we are able to get them because we've got a particular way of recording those precedents. We call that a precedent. Now, another feature of common law is that it is an adversarial system, or a contest between two opposing parties before a judge who adjudicates the matter, or a magistrate for that matter. Now, we know normally that you take someone to court, they have defamed you, and you take them to court. So it's going to be a contest, or it's going to be litigation between two parties, one enforcing their rights and one defending their conduct. The judge is presumed to be impartial in adjudicating a matter, But certainly we cannot be naive by assuming that judges are superhuman beings or they are better than other human beings. To this, the post-apartheid legal culture appears to be ambivalent about the law. It recognizes its shortcomings as well as its promise. This is not surprising, Mr. Chairman, given the role of law in an apartheid society, where it served as both an instrument of oppression and as means of resistance. We know exactly the well-documented history of South Africa that apartheid was legalized. That's why sometimes when someone is talking about law, we should not be naive to think that law is always right. Because during the apartheid times, the law was used. It was law and it was legal, but it was used as means of oppression. It was a tool that oppressed a particular race and color. So when someone speaks about law, we should not be naive or think that they are speaking about a holier than thou type of a tool that a society can use to live, or someone is talking about something that is really out of this world. It means that it's a set of legal principles that they can be used to frustrate or to advance the cause or the common goal of humankind. I think it is prudent, Mr. Chairman, and your leadership to applaud that these types of platforms are very good so that we can expand and expatiate on knowledge, but more importantly, the correct knowledge. As I've alluded just a few seconds, there is common law, and one would ask, how did common law reach South Africa? Mr. Chairman, I'm not a historian, nor I intend to start now to be one. And in this lecture, I do not intend to deal with origins of common law. It would take us a lot of time. But it is important at least to note that at least as of 2021, the 4th July, we have in South Africa a set of legal principles known as common law. But it originated, Mr. Chairman, in 1806. The English colonized the Cape of Good Hope. We know, Mr. Chairman, that would have been preceded by 1652 when Jan van Riebeeck first landed to the Cape. That we know, and it was also the law started there. Because when they came into South Africa, they came with their law. Hence, it is common law. Then, subsequent to that colonization by the English, the British settlers acquired the colony from English and brought a different language and a legal system to the Cape. What that meant is an amalgam or a mix of two legal systems, the English and the Dutch. That's what today we call South African common law. I can, without fear of contradiction, say to you, Mr. Chairman, that common law as is today in South Africa is a product of colonization. Now, normally when we speak about that, it does not sit well maybe with other people due to the nature and the history of this country. But I submit, and I submit further, that it is a fact. Common law is a product of colonization. The courts that operated around the 1800s, at around 1828, 1830, were replaced by a Supreme Court that mainly had...
Guys, can you mute, please?
Thank you, sir. So they were replaced by a system of a Supreme Court that had exclusively British judges, and it was later introduced a new system of lower courts presided over by colonial officials known as magistrates. So the question that one must have is that the system that we have of having judges, magistrate, is not authentic, it's not original to us. It is a system that was brought by our colonial masters, and we are living with that. That is for historians and perhaps politicians. It's not within the scope of this lecture. common law then became a practice law at the Cape and in the so-called colonies, the Natal and the Chaka republics, as it were. And it moved swiftly and sailed to southern Rhodesia, which is now Zimbabwe. And you know that sometimes they use our law or they use South African law most of the time, Namibia, Zimbabwe, and Nigeria, and Malawi, and many other countries that were colonized by the British or the English. So therefore, Mr. Chairman, you find South African common law is mainly Roman Dutch law and English law. Now, because of the evolution or because of the affliction of time, Mr. Chairman, some principles of the Roman Dutch law are not entirely part of our law. That is due to the advent of the Constitution, both the 1993 Constitution and the 1996 Constitution. At least to some degree, it brought light. Later in this lecture, we'll deal with that as well. Then, Mr. Chairman, in 1909, common law became an established or an accepted basis for South African law. Hence, today we are speaking about South African common law. It became an established law upon which all disputes in 1900s are going to be dealt with or resolved and adjudicated upon. And that meant, Mr. Chairman, that the next higher topic, that subtopic I'm going to deal with now shortly, is common law as a source of law. This history that I've given you in brief meant that, as I have said, that common law is now going to be a settled legal system in South Africa, or the main legal system. Because remember, in 1900, we were still colonized. Coming up, we were still colonized 1940, 1950, 1960s, we were still colonized. And it meant, therefore, that the law that was used is going to be our basis, is going to be the source of law. And I can tell you now, even today, we're able to share the wisdom of those cases. I don't want to get involved into the complexities of whether they are right, they are wrong. But what I'm telling you is that common law is a source of law in South Africa. It is an independent piece of law, apart from the Constitution, apart from the customary law. Now, it is clear, Mr. Chairman, that South African common law is a mixture of the wisdom or the rules extracted from Roman Dutch law and some English law, which have been combined by courts to give what we know today as South African common law. Some of these Roman Dutch legal principles are still applicable in our courts, Mr. Chairman, and examined by our courts and are still applied. And maybe I can give you a question or an assignment. What must happen when a common law principle is at loggerheads with the Constitution? Maybe we'll attempt to answer that as I am drawing close to the close. There's a case, it's one of those cases. It's mine workers investment versus Modibane, in which a long, very old common law principle called amende honorable, that is an apology, that was recited or that was relied upon and correctly, in my view, used by Judge Willis at the time. He says that even if the amende honorable had never existed, the imperatives of our time would require its invention. In my view, it is entirely consonant with the spirit, purport, and objects of the Bill of Rights in our Constitution, that a person who has committed a wrongful act by defaming another should, in suitable circumstances, be given an opportunity to make appropriate public apology instead of paying damages. And no less importantly, that the victim of the defamation should similarly have the opportunity to to have a damaged reputation restored by the remedy of a public apology. One of the key concepts that we have in Africa is the concept of Ubuntu. When I was reading this judgment some time ago, it thought and it resonated in my mind that actually it is human to wrong someone else, or perhaps we sometimes wrong people without intention. And this judgment says, if that then was not by intention, you are afforded a chance to say, I am sorry, and make a public apology instead of being penalized or paying those damages. And I think, in my view, it is a correct way of doing things. As I say that this particular apology principle is an old Roman Dutch law principle. It was correctly utilized, and correctly utilized insofar as the Constitution and the Bill of Rights were accommodating or allowed it to be applied in that particular context. I am saying, Mr. Chairman, that even if the common law as it is, it has got its roots. Some of them are not pleasant. Maybe some of them are useful. But Mr. Chairman, I'm saying today we have a constitution. You correctly said that our constitution is hailed to be one of the best legal documents ever drafted in the whole world. But Mr. Chairman, I'm saying common law should be applied, it is my view, within the context of the constitution. Or put differently, the constitution should be the standard for applying common law. To an extent that if the constitution does not allow, then we should not apply common law at all. Because as we know, that constitution is a social contract. This leads me to the next sub-theme I titled Constitution and Common Law. In the beginning, I said that common law at some stage became a settled legal principles. It became a body of law in its own right, and it became a foundation or a basis of South African law. And it was used during those not so good times, the apartheid times. And we know that it can be used, or it was used at the time as a tool to oppress. I am not entirely sure, Mr. Chairman, whether we can retain all the common law principles as we have in South Africa, or some of them. Some of the common law principles are still extant. I'm not sure if we can retain all of them within a constitutional dispensation or within a constitutional democracy. But I think maybe how to retain, or should we retain it or not, it's a subject and a topic for another time. Now we know, Mr. Chairman, that and your leadership, that the Constitution started or was adopted in 1993, the first draft of the Constitution. It was Act 200 of 1993. And we have now a final Constitution that is extant, the Act 108 of 1996. It changed the legal scene in South Africa, or the legal atmosphere in South Africa, because it brought about the fundamental law, it brought about the fundamental values, and it became a supreme law even more than a common law, because it enjoys, Mr. Chairman, an exalted status that can only be amended according to its own constitutional provisions. Then, Mr. Chairman, we entered a new dispensation. We entered a new turf or a new environment, and we call that environment or dispensation a constitutional democracy. I must be honest and say, Mr. Chairman, I find it curious that South Africa has a written constitution, yet the United Kingdom, which colonized the country does not have a written constitution, but I'm not a historian. It is not within my scope, but it was just an observation that I had made. In the United Kingdom, there exist only few different laws and conventions that are strictly adhered to. They don't have a constitution written as ours. Yet they say our constitution is the best, Mr. Chairman. I'm saying these things not because I'm inciting, but I'm intriguing, or I'm triggering a debate in one's mind. When the chairman of the SALT was talking about the pillars of SALT, one of those pillars is knowledge or development of knowledge. And I'm actually appealing to our mental side, to our cognitive side of life, to start to question these things so that we know exactly where we are going. I know there is a notion that says, for you to know where you are going, you must know where you are coming from. But I'm saying, Mr. Chairman, to know where you are going, start where you are at the present. In the present, we have a common law, and we must investigate it. We must investigate its origins and decide if it's still suitable to be part of our law. The Constitution, as we know it, Mr. Chairman, binds everybody. No one is above the law. And recently, it has been said even in television. This phrase, "no one is above the law," is common. If you turn on if you switch on your television now, journalists are talking about it. All news stations, all radio stations are talking about it. No one is above the law. That is our Constitution. Whether it's true or not, I am not sure. Now, what that means, Mr. Chairman, is that if the Constitution binds everybody, it means it is the supreme law. And we know that the Constitution has one of the clauses or sections. It's called the Supremacy Clause of the Constitution. It's Section 2 of the Constitution. It speaks to the fact that the Constitution is the supreme law of the Republic, and that all law must be consistent with the Constitution, failing which is going to be declared invalid. And the Constitution, it has got an important section which is called the Bill of Rights, that affirms democratic values of human dignity, equality, and freedom. Again, even the common law must be tested against those norms and standards. Now, Mr. Chairman, the Constitution recognizes common law because the common law, as I said, finds application or finds recognition in the Constitution, and the Constitution says it must be applied consistent to the constitutional values or the constitutional imperatives. In particular, Section 173 of the Constitution exhorts the courts to develop the common law, taking into account the interest of justice. I imagine this section to mean that in 50 years to come, some of the old Roman Dutch law principles will not be applicable. I imagine this section to mean that some of the old English law principles in 50 years to come, when we are no more, some of those principles are not going to be applicable. Why? Because there is a particular obligation conferred upon courts in South Africa that the judges should develop the common law, taking into account the interests of justice. I'm reminded, Mr. Chairman, of what the former Chief Justice had to say, Justice Arthur Chaskalson. He said, "The law provided the foundations on which a racial discriminatory society was built. In all this, there was, of course, a conflict between the common law, which denies all forms of discrimination and recognizes and seeks to protect fundamental rights and freedoms. And on the other side, the bureaucratic state, which increasingly claims the right to decide for people and how they should lead their values, their lives, and how privilege should be distributed. This attempt to create an apartheid superstructure upon an infrastructure of Roman Dutch common law called for an schizophrenic approach by Coase to problem solving. They were at one and the same time being asked to articulate and give effect to equitable common law principles and to uphold and enforce discriminatory laws, at one time to be an instrument of justice and at another an instrument of oppression. That's what common law is sometimes attributed to. At once it was an instrument of oppression, and sometimes now we try those same principles to apply them within the constitutional dispensation. But one would ask a very difficult question. Is it necessary for us to retain all the common law principles or all of them? Not even some of them. That is a very difficult question. We know, Mr. Chairman, that a lot happened insofar as legal developments after 1994. The relationship between common law and the constitution is tense and sometimes confuses the very legal people that are bestowed to interpret. In view of the history recounted above, this should not come as a surprise. South Africa's European legal heritage has been associated with authoritarianism, racial oppression, and economic exploitation, and is today seen by many as detracting from the legitimacy of common law rules. Mr. Chairman, you know exactly, recently we witnessed a judgment that I call a jurisprudence we do not want. The judgment that we know the Secretary of the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, including organs of state, versus Zuma and others. Justice Theron in that judgment remarked as follows: "It is not enough to say, as the main judgment does, that the common law allows punitive committal to be ordered in civil contempt proceedings. The Constitution is the supreme law of this country, and the common law is only instructive to the extent that it is constitutional." Mr. Chairman and the members of SALT, we are at that point where we've got rising tensions between common law and the Constitution. And I think this, at paragraph 192 by Theron J., it is a critical observation to make. And I tend to agree that even if common law, if we find that common law is not constitutional, then we ought, in my view, not to apply it, because it undermines the very constitutional dispensation we are currently in. It undermines the constitutional project that we are currently in. I submit, Mr. Chairman, that this tension, if it is left like this, it will cause a lot of legal uncertainty and a bit of confusion, and may be used by others to purge others. It will create a confusion as opposed to legal certainty. It gives rise to a question of whether should we keep common law as part of our legal system, or which law should take precedence when the Constitution is at loggerheads with the common law. But I am reminded, why do we have this problem when we have Section 2 of the Constitution that says the Constitution shall be the supreme law of the country? It means, Mr. Chairman and the members of SALT, there is a problem. Maybe the problem is because we don't want to let go of those common law principles. And I think, in my view, it is high time. If we can't have two bulls in one kraal, we know if you've got two bulls fighting in one kraal, the grass suffers. I don't want to imagine that the grass to be the human beings on the ground. Because the very same constitution speaks about the rights of human beings. And Mr. Chairman, it is my view that the application of common law has reached a stage that it is enough that it served as a basis for our law. Or maybe I would say it has run its course. And going forward, we have to uphold the constitutional project. A constitution is called a social contract. There are many values that are listed in the constitution. There are many rights that are listed in the constitution. And I think, Mr. Chairman, if we are to invoke common law principles, when we have enough on the constitutional imperative, we are causing a problem like this judgment. As I say, it is a jurisprudence that we do not want. We know, Mr. Chairman, while we are at it, there is a duty on this side by the very same constitution. Section 39, subsection 2 says the courts have an obligation to develop common law. But it has got a caveat, and that caveat is with due regard to the spirit, purport, and objects of the Bill of Rights. Where a court develops the common law, the provision of section 39, subsection 2 of the Constitution oblige it to regard to the spirit, to have regard to the spirit, purport, and objects of the Bill of Rights. I wonder if that happens every time in our courts. Even if it does not happen, it seems to me I imagine this section to say, if there is a common law principle on this side, and there is a constitutional principle on this side, and they are not speaking or they are not in sync with one another, choose the constitutional principle. Because at this point in time, we have a law called the Constitution. And that Constitution, by its own provision, it is the supreme law of the country. It even supersedes the common law. And I submit, again, I think that the common law maybe has run its course, and it is the time that we let it go or we relinquish it. Obviously, to the extent that that is constitutional. In exercising their powers to develop the common law, judges should be mindful of the fact that a major engine for law reform should be the legislature and not the judiciary. There is a common notion, even among law students, they will tell you that there's what we know, we commonly known as the judge-made law. That's how these precedents, that's how common law was brought in. All these old decisions that were developed over time, they became law. But it seems to me that judges should be mindful of the fact that a major engine for lawmaking reform should be the legislature and not the judiciary. I'm not saying that cases that are decided on a daily basis do not serve as law, but their first and foremost duty or responsibility should not be lawmaking, but should be problem solving. There are judgments sometimes, Mr. Chairman, when you read a long judgment, and you wonder if someone in the very, very, very deep rural areas would have access to this document. 1. 2, would understand the intricacies in this document. 3, would, after having done so, let's assume that he have read and understood, would he or she conclude that this is the law that we ought to abide with or abide? It is so crucial. And it is at this juncture that I recall the words of Kendrick J. in the case of Du Plessis versus de Klerk. He says, judges can and should adapt the common law to reflect the changing social, moral, and economic fabric of the country. And I think he is correct, and I tend to agree with him. Judges should not be quick to perpetuate rules whose social foundation has long since disappeared. Nonetheless, there are significant constraints on the power of the judiciary to change the law. In a constitutional democracy such as ours, it is the legislature and not the courts which have the major responsibility for law reform. The judiciary should confine itself to those incremental changes which are necessary to keep the common law in step with the dynamic and evolving fabric of our society. I tend to agree. It is true, it is a fact that our society has changed. The class of 1976, Mr. Chairman, will tell you that things are different. The class of 2000 will tell you that we don't live in the world of 1976, and so on. What it tells us, the social fabric or the society itself has evolved, it has changed. And we ought, it is my view, to move with the changing times of the society. In these circumstances, Mr. Chairman, the courts must remain vigilant and should not hesitate to ensure that the common law is developed to reflect the Bill of Rights. In addition, it is submitted that this duty upon judges arises in respect of both civil and criminal law. The influence of fundamental constitutional values on the common law is mandated by Section 39, subsection 2, Mr. Chairman, of the Constitution. And it is within that context that common law must be developed. Mr. Chairman, as I draw nigh to the conclusion, I want to start by saying, even if a legal system rested on a legal certainty and laws equally apply to equals, if it is bereft of justice, the very foundation of law, it is not law at all. The essence of the term law is that it must be just. If the law is not just, it is not law. Those who prosper and are wealthy may not care about laws that do not affect themselves, even if those laws have negative consequences for others in our society. Maybe that reflects our society today. There are people who are going to tell you that the Constitution applies. They are going to say it is a constitutional right to do this and that. Maybe that is true. Maybe that is because it has not yet affected them. However, Mr. Chairman, if some people in our society are subject to laws that bar them from advancing in their lives, and where there are profound deficiencies and imbalances of wealth and power, those people will have no difficulty identifying the immorality of such laws. And if their lack of power prevents them from having the laws changed, perhaps choose to treat them as no laws at all. You know, Mr. Chairman, and the members of SALS, that in South Africa, there is a trend of mass protests. Or in fact, in Africa, currently we have a situation in Eswatini that is caused mainly by the laws that are in place. Some regard the laws as no laws, hence there are protests. Because they are not laws that they are advancing the common good. They are laws that are protecting the few. And Mr. Chairman, that is not how a society should live. A society should not live by satisfying a few people who are most powerful. An ordinary man on the street must be able to claim their dignity, to claim their space, because they feel like the laws that are being applied are just and therefore they are laws. Mr. Chairman, our constitution is hailed as one of the best legal documents in the whole world. But is it just and fair to an ordinary man on the street? Maybe I don't think so. Members of SALT is the position, I think, that the South African community finds itself in. It is common knowledge that there is a gap between those who are rich and those that are poor, and this gap is very wide. It is even worse during times of COVID and subsequent lockdowns. What we see and experience today is not new, but was made visible by the calamity of COVID-19. If I am correct on this, Mr. Chairman, the question arises, is the current law just? If I am wrong, why should there be so much injustices if the law is just? I'm going to repeat that, Mr. Chairman, as I'm appealing to us all to be able to question these laws and these legal principles. If I am correct on the above, the question arises, is the current law just? And even if I am wrong, why should there be so much injustice if the law itself is just? We must think about those.
Oh, yes.
I think it is important to raise these questions because laws are made by human beings and applicable to the same human beings. I recounted earlier, Mr. Chairman, and I said, even if the laws are sometimes or to a certain extent limited, made by judges, we cannot be naive and think that judges are superhuman or are human beings in a different class or are human beings in an extraordinary class or are human beings or deputies of God. These questions, Mr. Chairman, we ought to have. We ought to investigate these questions and be able to provide answers. In your address, I remember you talked about the fact that we must be able to appeal to the leadership in our inside. And you said it is one of the founding pillars of the movement, SALT. And I appreciate, Mr. Chairman, that it is one. Why these questions are important? It is because a human life is precious and irreplaceable. Recently, or in last year, we witnessed a murder of Floyd George in America. I understand that there was a case for damages. Let's assume that they would have succeeded on the damages case. But I'm telling you now, they're not going to regain the life of Mr. Floyd George. In South Africa, we see many cases of members of the South African police being brought to book, the Minister of Police, and so on. I agree, they get monetary compensation, but the life is irreplaceable. And it is within this context that we must investigate and start to question the laws because they apply to human beings. None of us wants to live in a society where people treat the law as no law at all, for obvious reasons. But with the same understanding, we ought to question the even-handedness of the law. As I close, Mr. Chairman, I've got these two provisions or these two suggestions, it is difficult to harmonize constitution and common law.
Can we mute, please, guys? Sorry, leadership. Sorry, Bob.
These two cannot be harmonized because common law developed to be an extrinsic set of legal principles in its own right. And those who drafted the Constitution saw that it is not enough or it is not good, and we need a social contract. Hence, the Constitution was born. It is my view, therefore, that to resolve the tension between common law and Constitution is not to apply common law, but to apply common law within the Constitution. Put differently, use the Constitution to interpret the common law. The result, in my view, will be that if you find that common law is unconstitutional, you will strike it down because you are using the lens of the Constitution. And therefore, it is within that context that I submit we ought to see common law and develop common law within the ambit of the Constitution to maintain constitutional order and legal certainty. Many countries that are plagued by wars now, members of the SALT, sometimes it's not because there is no law, but sometimes there is confusion with the law they are having. We have experienced many countries with wars in Africa. When you look closely, sometimes it is not because there's a gap between the rich and the poor. Yes, it is a contributing factor, but sometimes you find that there is no legal certainty. And I submit, therefore, we can't entertain the tension between Constitution and common law for long. Otherwise, it will lead to a confusion and will undermine the constitutional order. Mr. Chairman, with those few words, thank you and the leadership of the South African Gentlemen's Club. Thank you, sir.
Leadership, all I can say is what a powerful presentation. I'm sure everybody on this call now understands the difference between common law, our constitution, and how things are not balanced within those that have and those that don't have. So because I don't want to take the shine, I know that everybody has been listening here. I saw a comment from Untitled Chapter saying, Mhlekazi, your conclusion statement of definition of law is so profound. There should not be no favor, no intended deficiencies for some, for law to be trusted for its purpose and justice. Thank you, Tata. True life will never be replaced if lost. So that's a comment from a member, our true member, one of our founding members, Mr. Butisipe, is saying how they feel about the law. And what I listened to and heard, the last 4 paragraphs from number 37 to number 41 or 40, they were, you know what, they made me think to say, who is the law, who makes the law, and who the law favors. Because if you look at how things are panning out in this country, you ask yourself a lot of questions. There are those that stand in front of the court. There are those that will never stand in front of the court. There are those that break the law every day and they will go to court. So if you look at everything that is happening at this moment, I know our chairman is saying, I so want to ask, I've got a question. Because if you look at, he's sitting by the side of the road and he's got a question that he wants to ask. And there's another statement from Mr. Butisipe saying, Mhlekazi, a question is it not that SA rushed to be padded to have the best constitution with lack to repeal or advance on looking at some common law imbalances to justice? You said it in your statement, leadership, to say, we've got the best constitution in the world. As it said, that's what the papers and Google and everybody's saying. But is it just, as you said, is it just a law according to you? So there's a question to say, didn't we rush to say we've got the best constitution? But in terms of implementing what's in that constitution, we are failing to do that. So I would love to hear your comment on this. in terms of did we rush to claiming that we've got the best constitution in the world?
Maybe I will begin by saying I appreciate the question, and it is a very good question. And I wish with me I would have the legislature trying to answer this question. Because what is the use of having a law that does not apply or that applies less to someone in Alex? What is the use of having a law that is not even known by someone in Ntabankulu, in the Eastern Cape? But to come to the question, Mr. Chairman and the members of SALT, I agree, yes, maybe we rushed. I don't think at the time South Africa adopted the constitution was ready for a constitution. But we cannot separate the law from the political dynamics. Because at the time, the political climate meant that we are going to have a constitution. I'm not sure whether we were ready to have it, because some may correctly say it does not reflect the indigenous people that we are. Many people have commented about our constitution and say, oh, this is a Western document. We can't shoot that comment or that feeling down, because it does not address one's needs. It does not address the concerns or the regards of that particular person. But to be precise, yes, I think we rushed. I don't think in essence we were ready. But maybe at the time, the political climate was not so giving insofar as having time to discuss. For instance, we've got today an issue of racism. We normally use the phrase, racism raises its head again. Some say raises its ugly head again. How many instances have you had that? So many. But we have a good constitution. But how can you have the best constitution in the world and you fail to address those things? To some degree, it tells that maybe we rushed. And maybe those who were the so-called haves at the time maybe had an upper hand, hence this constitution. So I think it was really not a conducive space, and maybe we didn't have time to sit through and actually investigate the type of society we are going to enter with the constitutional democracy. You know, many African states were colonized, many of them. But they had different transition from apartheid or from colonization to being freed. So it is within, in my view, that factual matrix that must be understood.
That was a very full-on statement, and I hope that Sipe, your question has been answered. And I'd like to open the floor for anybody who's got a question or a comment addressed to our speaker, the advocate, not to be shy and to tell us exactly how they feel or any question that they may have. There's a hand from our chair, Mr. Paul Tlabakwe. Sir, the floor is yours.
Thank you, leadership. Thank you. I must commend to leadership Sete for a brilliant and wonderful presentation. Shows that he has really not taken this for granted. They've taken time to research and come to us with solid information that will build us going forward. Leadership City, I have a little bit of a confusion that I want to you to clear up. And I understand that you see the Constitution the way you see it, and your last comment has really gave it away how you see this Constitution to be. But I really want to step back a little bit, back to the issue of common law. Would I be right if I say the common law that we're talking about, that is found to be unjust in most cases, it is derived from the common law from the Dutch British Constitution, not from a natural common law from God? Remember, I used to remember we've been told that South Africa is a Christian-dominated country. That's what I used to hear. And I used to know that in schools we do what you call a Christian class. I can't remember the name that we're doing. There was a class that is a religious class when they pray and do all those things. And all those things have been removed completely from the classroom. There's no religious training now at school where they used to have that. And my simple question would be, this constitution that we have, and the common law that you define that comes from the Dutch, British constitution or life, would you say they are based on the futurist or they are based on God's principles?
That is a very profound question. When we were talking, I remember that my brother was doing at some stage a course or a subject called biblical studies.
Yes,
where they
that's what I want.
Where they learned of many issues with regards to the Old and the New Testament and the writers and so on. Now, being a Christian, I think the Constitution was, or maybe to track back as you did, the Constitution is not necessarily a product of the Christian values, so to say, because it itself speaks about many things that you would say maybe would not be found in a Christian community, so to speak. And it was, as I said, a coming together or a compromise. I think that's a correct word. And that's why we don't have now a Christian education. It's because to some degree, and I think to a large extent, we have lost the Christian fiber that used to be part of South Africa. Whether that is good or not depends on individual interpretation. But as a Christian, I would think it is not, because I remember there is now a move to say everyone must do whatever they want to do according to their likes, according to their convictions, and so on and so on. Maybe some would say that is correct because it accommodates different types of religion, different types of lifestyle, different types of many things that as human beings we are exhibiting, or we live to exhibit. So it's a bit of a difficult question, because someone who's not a Christian would say, no, you're actually imposing on me to be a Christian. But you are correct by saying South Africa, at some stage, we grew up knowing South Africa to be a Christian state. And largely, the common law was not necessarily from the natural law of God. There are schools of thought currently, or maybe there are not two, there's quite a few, but there are two dominant schools of thought. It's the natural law school of thought, and it's the positive law school of thought. Now, the naturalists believe that there is law apart from the law that is made by human beings, and that law is made by God.
Yes.
Now, and one of those, the founders of the natural law school of thought is a guy called Marcus Cicero. And he at one stage says that true law is right reason with nature. And he goes on to say it is the law of universal application.
Yes.
It is the law that is eternal, that does not end.
Yes.
Now, like I said, there was a bit of a striking a middle ground with the Constitution to say, let us accommodate some who is not a Christian, some who has got a different religion. Hence now, maybe we don't have a harmonized society. Sometimes we overemphasize our beliefs more than the common good. For instance, there's a value that is only found in Africa, the principle of Ubuntu.
Mm.
Now, you can interpret it to be Christian because it is good to do good to others.
Yes.
Because all human beings are created by God. So, in short, I am saying it is within that context that whether the Constitution was good or was bad or has got limitations or shortcomings, of which I admit it is not without faults. Constitution is not a perfect document. Hence, it has been amended for many times. So that's why I'm saying Constitution was a compromise to accommodate everybody who might not be pro-constitutional country as South Africa used to be.
Yeah.
Thank you very much for that explanation, leader. And I see the chair is back again. The chair is back again. I see the chair is the only one that is raising his hand. Guys, don't be shy to ask. It's also your platform. It's not a discussion between the chair and the advocate. Let's also engage and get explanation and answers on any question that we have. I'll give it back to you, Mr. Chair, to tell us your question, your comment to the advocate.
Yeah. Yeah.
Maybe. So sorry, Chair. There's a question on the chat box. The question was asked last Friday on the Pabasa's presentation. The question was, should the law be applied for nothing but the sake of law, or should it applied with justice in mind? I would like to hear the presenter's sentiment. One of my concluding words were the following. The very essence of the law is justice. So if the law is not just, in my view, it is not law. The measure of a just law is not to test it to the people that are wealthy or the haves. But maybe, in my view, the correct measure is to the people who are most vulnerable, the poor of the poorest. And therefore, I say that the test for the law is not the law itself, but the just fiber of the law. And therefore, I agree with the sentiments that we can't apply the law just for the sake of applying the law. Remember, the law is applied to human beings. Human beings are not goats. Human beings are not sheep and so on. Human beings are a precious piece, are a precious soul. And therefore, we can't treat and say, this is the law, and therefore this shall be like this, even if that law is not just. So again, I'm saying the very important backdrop of the law is whether that law is just. And in my view, if it is not just, it is not law. Mr. Chairman, you had your hand.
Yeah, thanks, leadership, for that. I think the jury is out that this constitution, by way of what it's giving this nation and what it's giving the guy in Lusikisiki who doesn't know anything about law, but we expect justice to be there. We expect resources to also be available to them, like they are to anybody else elsewhere in Sentin or in Johannesburg. It's not doing that. I mean, it's not. This is a fact. It's not it's not a almost I want to call it a rumor. It is a fact. So we look at issues such as, and you have mentioned one of them. We look at issues such as if when these corporates, which are meant to serve the people, fail to serve the people, they collude on prices to milk the very people that are poor. They are being given penalties by the Constitution, I mean the law, by all means, such that they end up paying the fines, which ultimately does not benefit the people who have been penalized. So in a way, when you look at the law, through and through, the Constitution, through and through, it doesn't support the people, the majority of the people. That's why it has built this so much unjust society that we're living in today. So my question would be, the naturalist, people who believe, like I'm a strong naturalist, who believe that there's a law of God, and it is the foundation of every law that is around. And as soon as you violate that law, you violate the foundation of our existence, because we were made in the image of God. So if there's any Christian out there and every believer out there understanding this today, that they are living in the Constitution, which is called their Constitution, but it doesn't support the law of God. It's very clear. Today we are told that Aaron Motsoaledi is legislating a law of women getting multiple husbands. Never once we were talking at Saljak, never once have you seen a petition on the street of the same women asking to marry more than one husband. We have seen women many times in the streets complaining and raising their concerns that they are not safe. They are being raped. They are being abused. We have seen men going out and say, we want land. We want to have our families housed and all that. Same constitution has never done that to them. And that is why we go back to the naturalist and say, should we all not go back to the naturalist common law that says everybody will have everything equal and it must happen. Everybody deserves safety and it must happen. Not all these laws and all these benefits or benefits that we have are taken away by deceptions away from us in that very name of better good. I was making an example when I started earlier that we are always told that these things are being done for a benefit of all, for a public or a greater good. But when you look at them at the end of the day, they are not being done for a greater good, public good, because the public is the one that suffers year in, year out, even though they vote. But the people who are implementing these laws, who implement these deceptive laws, are the ones who are suffering the most. So should we not, that's my question, not to go long, go back to the natural law, the appropriate natural law of God, not the natural law that we spoke about that was derived from the the Dutch English constitution. The natural law of God, where the people, because the law is made for the people should have a say in the law that is made for them, not the law that is made and people are told that is the best law in the land. That's my question.
My question is overwhelmingly yes, because like I had said, human beings are not objects, and therefore, even if we can have the best of minds making the law, that would not be perfect law. Because by design, human beings are not perfect. And in any event, by making the law for someone else, would not include their circumstances, would rather include or have regard to the lawmaker's circumstances, as opposed to someone who is at Lusigi and Ngobo and Alex in the outskirts of Kroonstad. So that is part of it. Then the second layer of it is, in South Africa, we seem to have tried many things and they didn't work. And maybe it would be an opportune time or an opportune avenue to explore that. One of the pillars of naturalist is that the land belongs to everybody. The land, there is no specific person that should be owning the land. I mean the land.
Yes.
But today you find one person owning hectares and hectares.
Yes.
And you find the workers of those hectares cornered in a particular place that is not even habitable.
Yes.
So maybe it is an opportune moment for us to reflect. In the Bible, there is a scripture in Jeremiah, if I'm not mistaken, where it says, stand at the crossroads and ask. Maybe we are at that juncture in South Africa. We've tried, we've got so many laws that are good, yet there is so much injustice.
Yes.
We've got so many programs, but the levels of crimes each day are escalating. We've got so much. I don't know whether it's tools and means, but something is not going right. Why is it that protests are going to be so much in a world or in a country that has got the best law? Why are you going to have so much of dissatisfaction among people when you've got the best laws? Something has to give. Something's not right. Maybe, Mr. Chairman, it is again the opportune time, the opportune moment for us to just stand at the crossroads and ask a question. Where are we heading? Where are we heading? Cover this South Africa. Where is South Africa headed to? One of the deficiencies that we have in Africa, I'm concerned and it hurts me every day. You find our presidents and leaders are mostly above 60. And it tells you that that person who is a president and is 65, is 70 years, will never have an agenda that is going to last for 50 years, because in 50 years he's not going to be there. Something has to give. Something has to give. How do you have an agenda that is going to enhance young people when you are 65 years? You are already at the close, or you are already close to the end of the end days of your life. So something has to give. I do agree, and maybe these platforms, Mr. Chairman and the members of SALC, are an opportunity for us to discuss, engage, and investigate and question these things. And by so doing, bring out, as you correctly said in the beginning, the leadership in us, the inner man, the leadership in our lives. And share the knowledge, but the correct knowledge.
Thank you. Beautiful.
Thank you very much for that. I think before we go on to our WhatsApps and our chats, I want to check Mr. Bongani Kaba has had his hands raised for a while. Mr. Kaba, can you ask a question, please?
And And can you please also note Mr. Zwelinzima?
Yes, I will start with
Yes.
Mr. Kaba, and then after that we'll have Mr. Mkwanas.
Thank you, sir.
Okay, good day, leadership. Can you hear me?
Yes, sir. Good day, sir.
Okay. Thank you so much to the leadership of SADC, as usual, powerful session. We've learned so much, especially for law. In these couple of days in South Africa, law has been very, very interesting for some of us. I've got two questions to you, leadership Sithe, and you've already touched partly, slightly on one of them. In South Africa and in terms of our government, what is your view on these so-called separation of powers between the executive, the legislature, and the judiciary? I'm bringing this up because in most cases, the executive has been quick to criticize the courts to say they are overreaching in some instances. So from your view, especially being the person in the actual fraternity, do you think that is accurate, or is it just the executive throwing their toys out of the court? And then the second question you touched on, you said the constitutional law is the supreme law. So does it mean that, and now I'm bringing this in the context of the constitutional court, and you can educate me on this one. So that what does it mean when someone appeals the constitutional court's decisions or rulings? I thought that is the final. How does it work? Yeah, briefly.
Firstly, let me start by saying, can you hear me?
Yes, I can hear
it. When you are not doing your job, someone else might close the gap.
Okay.
I've watched Olympics, athletics, and I've noted with an interest that actually there are lanes that are allotted to each runner or to each athlete, to such an extent that if you encroach on my line, you are disqualified.
Mm-hmm.
I think the issue of separation of powers has not been taken serious, because if it was, this analogy of runners in the running course would have been at least used to say, if the judiciary is lacking, the executive might come and encroach because they are not doing your job. Or if you are coming to me, you are coming to my line, it's bound to be a fight, and one of us is going to be disqualified. Whether the separation of powers is a fallacy or something that we must really abide by, it's another different story, Mr. Kaba. But I know that this idea of separation of powers is a German principle. It's called trias politica.
Okay.
Now, the idea behind that, I'm not sure whether it is still now in South Africa, was to try to avoid a conflict of interest and an occasion of bias on the side of the executive appointing certain people, or on the side of the executive overriding into the field or to the ambit or to the turf of the judiciary, and the vice versa. So its foundations, I believe and I think, were noble. Whether we are doing that or not is a different story altogether. But let me tell you, human beings are not without faults. Human beings are not perfect. But I'm not overemphasizing our imperfections. But I'm saying maybe this is bound to happen because maybe by design or by nature, human beings are biased. By nature. Now, I remember Sikakane SC making a very important observation. He said, one of the things that we have to deal with is the bias itself. Whether you are a journalist, you are a lawyer, you are a member of the public, will I deal with this person as I would have done if it was someone else? That is an intrinsic question. And if the answer is not in the affirmative, you are biased. And from that must flow a recusal or a caution. I once appeared in a court where I knew the magistrate. When I entered the court, I was like, oh, I've seen this face before. And the look, he also looked at me and like, I know this person. We have not gone into details of the case. He said, let me be upfront to everybody. I know Mr. Ngombane. I've worked with him. And I stood up and confirmed that I know Mr. So-and-so. I've worked with him. He further said, I elect to recuse myself for someone else to take over the case. Because even if there is no bias, there is potential bias that may arise. Because I've worked with him before. So maybe to someone who's going to be sitting in court watching and listening, if I find in his favor, there is a likelihood that that person will be like, well, in any event, they've worked together. There was a human sympathy in some way or the other that was towards Mr. Ngombane. And when I was sitting at home, I had two questions. One, was it correct for him to recuse himself? I said maybe yes. And the second question was, maybe if we were all like that, even if you see something potential, not actual, you say, I may not be honest here. I may not be authentic in this, that which I am doing, and therefore let me step aside. Maybe that separation of powers principle would be upheld correctly. Like I said, its foundations are noble, no doubt. But whether we're doing that or not, it's something really different. And I can say we have tried. I think to some degree South Africa has tried. And by the way, Mr. Klaba, the community of South Africa is a very, very, very unique community. I think it's not found in the whole world. You've got different people in South Africa with different ambitions, different backgrounds, different political aspirations, different legal aspirations, and many other issues. And you know the history of South Africa. So within that context, I think the ideals of the separation of powers are correct. Then the second question about the Constitutional Court being the last court or the final arbiter, you are correct. That is yes.
Okay.
But there is, I think, I'm not sure of the rules in the rules of the Constitutional Court, a rule that says a Constitutional Court may reconsider its own decision. I think part of the reasons why it will consider is because it would have, in hindsight or by any chance, interpreted wrongly a constitutional principle. For instance, in the presentation, I alluded to the fact that there was at loggerheads in that judgment, two laws, the common law and the constitution. And my view is that you can't apply the common law over and above the constitution, because the constitution is the supreme law of the country. And if you do that, you're actually saying, no, hang on, the constitution is just like any piece of subordinate legislation, of which it's not. And now it's a different argument that would cause us, legal uncertainty and confusion. So in short, yes, there are means and factors that the Constitutional Court would reconsider its decision. Thank you, sir.
Thank you so much, leadership.
Thank you very much, Mr. Kaba, for that question. And Mr. Zwelinzima Mkwanazi, it's your turn now to ask the advocate your question, sir.
Thank you very much, Chair. First and foremost, let me just declare that I'm not a person in the law fraternity. I'm a teacher and a headmaster at my school. But let me allude that now this presentation has been an eye-opening for me. And just want to thank the person who sent me the link. Look, I'm just checking. My first question will be on the issue of saying, as a principal of a school now, how do we apply the legislature in terms of the policies that are set out in the Department of Education vis-a-vis the common law and the Constitution itself? Because we are to deal with the Constitution based on the policies that are given out by the Department of Education. Secondly, I just want to check what is the difference between the common law, the rule of Amakosi, as I'm from Northwest in Potchefstroom, where Northwest is mostly rural, and the Constitution itself. As I see that now, there is always a kind of conflict between Amakosi and the Constitution, even though I know contraless and everything, they are in the support of our Constitution. So I just want to check on that, and let me really thank you guys for this presentation. I thank you, Chair.
Thank you so much, sir. Maybe let me start with the last question that deals with the conflict between customary laws and the Constitution.
Yes.
I think that is one of the difficulties that we are currently facing, where a customary principle would not necessarily be applicable unless it passes the constitutional scrutiny.
Okay.
And in most cases, you find that a lot of customary principles are not constitutional. Now, the fact that they are not constitutional is because the Constitution is a prevailing law. It's not in itself right or wrong. By saying it is unconstitutional, we may not necessarily be saying it is wrong or it is right, but it is just the standard that has been placed because the Constitution is the highest law in the Republic of South Africa.
Yes.
How do we resolve the impasse, therefore? I can admit upfront, it is difficult.
Thank you very much, Chair, for that. So there's a question in the inbox that says, how can application of Constitution become just? It's a question for Bapiwe Daweti. So that's the question. How can application of Constitution become just? So I will hand over to you, my leadership, to answer that question.
Thank you, sir. Let me finish, Mr. Zwelinzima. Now, it is, I said, very difficult, and it would need a coming together of human beings with common goal, without forgetting that South Africa was colonized, and therefore all of its original laws are in a way frustrated and not applicable by design of the Constitution. Someone was complaining to me the other day and saying, actually, Constitution is just a document to deprive us of our customary law. That's how we perceived it. Yet the Constitution on the other side recognizes the existence and the application of customary law, but to the extent that it is constitutional. So you've got that challenge, Mr. Zwelinzima, and it poses to us and to everybody a challenge. And I support the ideals of soldier, because we must challenge, we must question these things, not because we want to defy the law, but because we want to understand the very basics of the law. And in any event, someone in the chat box said the constitution was just a compromise that was made to pave a transition for different kinds of people to live together and be tolerant. Maybe that's what we must do. The second question that you asked, Mr. Zulinzima, referred to the policies of the department vis-a-vis the constitution. Now, they are so-called, the right to education is in section 29 of the constitution. Now, I normally read that right with section 2 of the constitution, that the constitution is the supreme law of the country. Now, these policies, in my view, must first be constitutional. That is, they must pass the constitutional scrutiny for them to be able to be applicable. Recently, we have seen in one of the high schools in Gauteng, where black children or black girls were being attacked by virtue of their hair, and I found that to be wrong, to be unconstitutional, because it's lucky that I've shaved my hair. But imagine if I had my hair not knit up, but the way I like it, would I be wrong? I don't think so, because it is my hair, and the fact that my hair is coiled and so on, and it's not straight like someone else's, should not be a problem, because I'm a human being created by God, just like anyone else. So that's why I'm saying those policies ought to be constitutional, because that act, when imagine in 2021 or in 2020 a young student defending himself or herself against the hair. I mean, who causes the hair to grow? It's not the student, because I find that to be repugnant to the very same existence of human being. It's more like you are questioning why that student exists, first and foremost, because how can she now be responsible for the hair and so on? I know we're responsible for the neatness and so on, but it is those policies, those principles that I think are not good, and therefore we can't accommodate them in our society, irrespective of where and who they come from.
Okay.
The question about how a constitutional principle can be unjust. The Constitution was made by human beings, and it has been amended over 16 times already. It tells you that it had to change because it is not good enough, or it does not accommodate a certain fundamental human right. There are many instances in which a constitutional provision would not be just. For instance, there's argument that says we can't practice customary law. Yet the Constitution recognizes customary law, but it places a condition that it must be constitutional. So you've got those things that even though it's a constitutional provision, and even in those constitutional provisions, you've got a right that about the freedom of religion, belief, and so on. Someone who has a certain belief, claiming that it is not accommodated in the Constitution, or it is frustrated by the Constitution itself, it then brings us to the very same question: is the law, even if it's the Constitution, just? And being just really is something that speaks to the reason, the humankind, the human in us. Thank you, sir.
Thank you very much for that answer, Mr. Site. There's a hand from Sihle Mkaka. Sihle Mkaka, can you kindly ask the presenter a question? Over to you, Sihle.
Thank you very much, Chair. Mine is on the matter of the Concord reviewing its own, decisions. So the first question would be, do we have precedents of such, ever happening where the court would have ruled one way, and of course they appeal in whatever process that is followed, and then it went, in the opposite direction. The reason why I'm asking is that, of course, we know that there's a case now with former president, and it's a case of which has a lot of political interest, and I think the second question to the advocate would be, what do you think would be the consequences, right, of the Concord, suppose backtracking on its decision that it has already taken? And from a confidence in the Concord itself, do you think then South Africans would still have, the same confidence that they have currently in the, in the Concord? Thank you very much.
Let me start by answering the last question. The impact or the effect and the end result of this commotion or the conundrum that the Concord is currently facing maybe is not pleasant. As I said in my presentation, that has got a potential to cause legal confusion or legal uncertainty, because it is now trying to unscramble an egg that really, in my view, should not have been scrambled, or at least in this way. So, in short, it will have consequences, especially insofar as the legal certainty is concerned. In a new society, you need clarity, you need clear rules. But with that same spirit, you need justness, if I were to put it that way, or the rules itself or themselves being just, and maybe the rules themselves not being applied in a legalistic manner. Like I said before in this lecture, that the laws that are applicable to humankind, and we can't treat that for granted and take it for granted. We must take it serious, because these laws affect humankind. Now, there is provision on the first question you asked. There is a provision that the Concord can revisit its own decision. Now, whether it sends a message, a bad message or a good message, it's a subject on its own. But I admit, maybe to some people, it may not be a good reflection or a good image of the court. But maybe it shows that after all, we are human beings. One of the sentences in this presentation were saying, even if the common law was developed by judges, we cannot be naive to think that judges are superhuman beings or extraordinary human beings, or even deputies of God for that matter. We can't be naive to that fact. And we must, in my view, be cognizant of the fact that humans or human beings are not all and all perfect. They've got shortcomings. They've got emotions. They've got feelings and so on. So it is within, in my view, that context that firstly we must understand each and every time there is a change. And secondly, there is a rule in particular with this matter of the Concord seemingly changing, not changing per se, but saying maybe let us reconsider that our judgment would have been harsh. For instance, the former president has been charged with not obeying the order, but the order said he must appear or present himself at the State Capture Commission. Now, the State Capture Commission, the Commission's Act says if someone violates that law, they may be sentenced. They may be sentenced to 6 months. And the Concord on this side sentenced the former president to 15 months. Someone was saying the Concord was not sentencing. Anything that is not 6 months is not a sentence to the former president for not going to the commission. It's a sentence for other things. And that is a sound argument, because the reason for the crime says six, or the penalty for the crime says 6 months. And therefore, while we know that courts have got a discretion, but the act that is constitutional says 6 months. You will recall that in South Africa we've got even the hardest criminal is afforded time to present his case or her case. That is because the Constitution demands that. So I don't want to get into the intricacies of this particular matter, but I'm just highlighting some of the issues that really would cause us problems if maybe the Concord would have said, no, we are not going to reconsider this. I don't know the outcome of the reconsideration application, but I think, to me, the fact that they have accepted a reconsideration application does indicate that maybe they are saying we might have been harsh or something else. But there is an indication along those lines. While it's not clear now, or maybe they are going to discuss it and say we still stand by our earlier decision. It's something else. But there's that indication, while I don't want to get involved into the intricacies of the matter. Thank you, sir.
Thank you very much for that answer, Mr. Ngobena. We're going to take the last question, because we all know that the session is going to have part 2, because I see people have a lot of questions that they want to ask you, but because we are limited to time, 4 to 6 o'clock. So the last question will be from our chair, which is Mr. Bo. So can you kindly ask your question to the advocate, Mr. Tabakwa?
Let me once again thank the people who have come here and leadership in Ngomane, the advocate. What I want to say, it's almost a comment if I think about it. I am happy that this issue of this constitution has been laid bare, extrapolated to bare bone. And my message to the Christians and the believers and the nation is you cannot have an excuse that you did not know that you belong to the constitution that is not supporting the will of God. That's number one. And to the officers of the law, I don't think you are here to police illegitimate legislations that are cooked up by the government that has overplayed his hand. Because if you look at what is happening now, this very constitution that we live in supports the gagging of information in the name of we cannot say this information because we are not in support of the source that where the information is coming from. I'll make an example of COVID-19. Every information that does not support the narrative of COVID-19, the coronavirus being a normal flu, it's not been taken serious, and it's not even given public attention because it does not serve the purpose of a certain a group of people. The information is very clear what we have received and what we have read, that the COVID-19 issue was a gain of function that was sponsored by Anthony Fauci in the Wuhan lab, financed by the American taxpayers, and basically us as well taxpayers, because our money comes from our mines here and goes to America and England. So those information, the Constitution defends that and protects that. We don't know about that information. And now our freedom is taken away from us by the very same constitution to tell us to wear a mask everywhere we go. We mustn't breathe the wind or the fresh air that God has gave us. So it is very clear, advocate, and I'm glad that you came, leadership. I need everyone to take it from here and go forward and start learning that they're actually living in the laws that are not supporting of the agenda of God. Because also if you say the constitution is the supreme law of the land, in other words, there's no any other ruling apart from the constitution. When there's a confusion or misunderstanding somewhere, we go to the constitution. We're actually saying the word of God or the Bible as the what did you call the futurist? The word of God is not a proper one. The constitution that is designed by a human being should be the one that takes precedence. So my point and my closing part is, I'm glad that we have brought this here. The people need to know that the constitution that we live in does not support the actual people that is meant for. And these constitutions and these organizations should be made for the people, not against the people. Thank you very much. I appreciate your time.
Thank you very much, Chair, for that conclusion. So I want to give it back to you, Mr. Ngomane. Your closing shots. And yes, your closing shot from your side, because we just had the Chair's closing shot. Can we have your closing shot, sir?
Thank you so much, sir. In 2 minutes, or in fact less than 1 minute, if the law is not just, it is not law. The test to determine whether the law is just or not should be and include the very poor people, the destitute. If the law is not just, it is not law. Because the test should not be someone who's well off. The test must be a man working in Lusigisiki, someone in Kailicha, someone in... Now, I've seen that there are informal settlements that are named after this COVID state that we are in. That law, if there's law, it must speak to someone who's living at social distance. There's an informal settlement in Cape Town called social distance. Exactly. So if the law is just, it must speak to that person, not to someone who lives at or stays in Rondebosch in Cape Town or elsewhere. And therefore, my closing short, Chairman, and the members of the SALT is that the laws are created or promulgated by human beings, and therefore they are not perfect. Thank you, sir.
Thank you very much for that, sir. If I look at the comments on the chat box, everybody's saying insightful, informative, we learned a lot, and thank you very much for the information that you have shared with us. As you said, Hora, if the law is not serving somebody in social distance, actually that's the first time I hear of that. So if the law is not serving somebody in social distance, let it not serve somebody in lockdown 4. So can we be served by the same law wherever we are? It must not choose if I'm in a suburb or in a shanty town, or if I'm poor or rich. So let it be the same law that we say. When I say to you, thank you very much for your time. To everybody on the call, on Facebook, on Zoom, when I say thank you very much for always responding to our invites. And we're saying there is part 2 coming. And with part 2 coming, I want you guys to come in guns blazing, because I know the advocate will also be coming in with guns blazing. So let's join in. Look at our post on Facebook. We are on Facebook. We are on Instagram. We are on Twitter. We are also on YouTube. So if you want to hear and listen to this conversation again, it will be loaded on our YouTube channel. So you can go on our YouTube channel as SALJEC. So look out for South African Leadership Gentlemen's Club, and you'll get all this information and our future events. Anything else that you want, you can go onto our website. It is also SALJEC. So find us. We are there because we want to serve you as not only the public, but we want to serve you as men of South Africa, so that you can go back and serve your families. And whilst your families are served, the community that you're living in will also be served. We want to say thank you very much for your time. Until we meet again, guys. Thank you. Happy Morocco. Aslalin. President Uchengo Nano Thank you very much, guys. I'm out.
Thank you, sir.